Good afternoon. Thank you for joining us. I'm Catherine Saldana, one of two mentor attorneys with the Dallas Volunteer Attorney Program. Before I introduce our guest speaker for today, I would like to tell you a little bit about the Dallas Volunteer Attorney Program for those of you who are not familiar with our program. We are a joint venture between the Dallas Bar Association and Legal Aid of Northwest Texas. So we partner indigent clients with volunteer attorneys who are willing to take on the work pro bono. The majority of our work is in family law, and the majority of the family law cases are divorces, but we do get adoptions. And so we are fortunate today to, especially during the month of November, which is National Adoption Awareness Month, to have Jenny Womack speak with us again about adoptions. Jenny has helped create many happy families since she began practicing law in 1998, a passion she exudes in her practice, which is limited to adoption, surrogacy, gamete donation, and family building. She graduated from the University of Texas School of Law with a JD with honors. She's quite accomplished, numerous publications, presentations, professional associations, and awards, both in Texas and nationally. She's currently the president-elect of the Academy of Adoption and Assisted Reproduction Attorneys. She's been recognized several years with Texas Monthly as a rising star and as a super lawyer. She's an annual DVAP speaker on adoptions for several years. She's also a pro bono attorney with us, taking on the more challenging termination of parental right cases. And she also mentors our pro bono attorneys who take adoption cases. Please join me in welcoming Jenny Womack.
Thank you, Kathy. I appreciate that. It is always a pleasure. I love being able to do this during National Adoption Month. We're just getting that started, and there's a lot going on, so it's always fun time. So I'm going to go ahead and jump right in. If you have questions, if you will put them either in the Q&A or the chat, I will get to them at the end. It's a little hard since I'm going to be sharing my screen to do it as we go, but I will get to those at the end. So let me share my screen and we will get started. Okay. So today we're going to talk about what you need to know about your first or even your 50th termination or adoption case. Get it to move forward. That's going to be fun. Here we go. So the statutes are all in the Family Code regarding this. Family Code 162 is adoptions, 161 terminations. A few other things you might deal with, UCC, JEA, standing, some other things are in those other chapters. So that is where you want to go. There are 2 steps to every adoption. The first is going to be terminating parental rights. The only time you don't have to do that is if the parents are deceased. The second step is, of course, final adoption, which by statute is supposed to be 6 months. Child's supposed to be in the home 6 months before you do that. The court is allowed to waive that for good cause, and we'll talk about that a little bit, I think, later. But typically, most cases are going to be around that 6 month or a little bit later. Some of the relative adoptions, they may have been in the home for years by the time you get to the adoption. These can be done separately or can be done in a single suit. Typically, I only do a single suit if it's a situation where child has already been in the home for that 6 month period. That's usually going to be my step parent and relative adoptions. A big chunk of my practice, I do represent a couple of adoption agencies. So a big chunk of my practice is newborn adoptions, and we do termination separate from the final adoption in most of those cases, because we want to get that termination done right away, and we can't do final adoption until 6 months or later. You do have to worry about jurisdiction, just like in any other case. You've got personal jurisdiction that can be waived, not fatal if it's lacking. This may sound like a law school course. Subject matter jurisdiction. UCC JEA does apply to termination suits. Technically, it does not apply to an adoption suit. So if you're only filing an adoption, technically the UCC JEA does not apply. But if you are terminating parental rights, you do have to worry about court of continuing jurisdiction potentially, looking at home state, things like that. I will say that there is a statute in 103, I've forgotten the exact number. Hopefully I've got that a little bit later. That does talk about where you file. standing. So who has standing? Standing is going to be in Family Code 102, 003, 005 are the main ones you're going to be using. It's going to usually be an agency, somebody who's been designated in a relinquishment, step parent, adopted parent of a sibling would have standing, and so on and so forth. There's several different things, but majority of them are either agencies, somebody who's been named in a relinquishment, step parent, or somebody who's had possession of the child for a period of time. If you've got a case that involves interstate placement, which means child is crossing state lines for the purpose of adoption, you do have to comply with ICPC. The only exception are for very close relatives, step parents, grandparents, aunt and uncle. So if it's a great aunt or great uncle, I've had those cases, you still have to comply with ICPC if the child is in one state and going to another. You are required to file an affidavit with every termination and or adoption suit that you file, stating either that you've complied or that you don't have to comply. So if everybody's in Texas, that's what the affidavit says. Everybody's in Texas, ICPC doesn't apply. And if you are dealing with interstate compact, there is a regulation adopted by the Association of ICPC Coordinators, Regulation 12, that sort of outlines what all is needed. We don't usually run into those on DVAP cases, but you might on private cases. So just beware, if child's crossing state lines, you need to be sure you are complying with this unless you are within one of those exceptions. Just because a parent brings the child across state lines to place the child does not mean that you're within that exception unless they're placing with a step parent, grandparent, aunt, or uncle. I've had that come up in a couple cases. Few things to be aware of as well. International adoptions. If the child is not a U.S. citizen, you could be looking at an international adoption. Those can get very complicated, and depending on the circumstances, may require an accredited entity to handle it. So an accredited adoption service provider. So if the child is not a U.S. citizen, you want to make sure you're looking into that. There may be some ways to work with it through immigration, SIJS, things like that. I've done a few of those cases in the last couple of years. So there are some things you can do. But if the child is not a U.S. citizen, you do the adoption without looking into all of that, the child potentially could be barred from getting U.S. citizenship, or it could be very difficult. So you want to make sure you lay the groundwork in advance. The other thing you want to be aware of are secondary placements. I've got a couple of these going on right now where the child was previously adopted, and for some reason that original placement is not working out, and so they are placing in a new home, a secondary placement. There are some restrictions on handling those cases that do subject you and the families potentially to criminal liability. So you want to make sure you are checking out these code sections that are referenced. And one last thing to be aware of, make sure if you are working on a private adoption that they are not providing any financial assistance to the birth parents or birth family. They can pay for their legal, counseling, medical. Now that's only going to apply to things associated with the pregnancy and the adoption plan. So if you're talking about an older child, they can't give them anything other than potentially paying legal for a lawyer. Because if they do, it's a felony under the penal code. So be very careful about that. The only exceptions are through licensed child placing agencies. So let's talk about the termination of parental rights. That is the first step, as we talked about. You can either voluntarily terminate people's rights, involuntarily terminate their rights. With a voluntary relinquishment, that's when you've got the birth parents are signing either affidavits of relinquishment or an affidavit of waiver of interest. Birth mother would sign an affidavit of relinquishment. That is laid out in 161-103. Can't be signed until at least 48 hours after birth. Got to have 2 witnesses and a notary. Can't be conditioned on post-termination contact or anything like that. The contents are delineated in the code as to what needs to be in there. When it comes to revocability, there are a couple of different options. If it is being signed to an agency, whether it's to the Department of Family and Protective Services or to a private agency, like the ones I represent, it can be irrevocable from the time that she signs it. If it's being signed to actual individuals, to the prospective adopted parents, then by default it's revocable, but for 10 days, becoming irrevocable on day 11. There is a provision where you can make it irrevocable for 60 days and it becomes revocable on day 61. The only reason to do that would be if you were sure you were going to get termination done in that 60 days. At this point, I haven't done one of those in years because I usually cannot get to court that fast anymore. It just takes too long. You also want to be aware of the Indian Child Welfare Act. If the child is an Indian child, the affidavit of relinquishment or affidavit of waiver of interest really don't do you much good, because in a voluntary relinquishment, they're going to have to sign ICWA compliant consents. We're going to talk a little bit more about ICWA in a little bit, but just be aware, if you've got a birth parent with Native American ancestry, you are going to want to check into whether or not Indian Child Welfare Act applies. A presumed or an acknowledged father. So acknowledged, by that I mean a man who signed an acknowledgement of paternity with the mother, usually at the hospital. I get those a little bit in my cases, some of my agency cases. Presumed father is typically a husband or someone she has been divorced from within 300 days of the birth. Even if they're not the biological father, usually an acknowledged father would be, but a presumed father, not uncommon for them not to be. They have to have their rights terminated or the presumption has to be rebutted. They can sign an affidavit of relinquishment, just like birth mothers. It's not signed until 48 hours after birth. Contents are the same. It's still the same code section. An alleged father, so basically not presumed, not acknowledged, just who we think is dad or could be dad, signs an affidavit of waiver of interest. Now, they can sign pre-birth. Theirs is irrevocable from when it's signed, as long as it states that in there, even in private direct placement adoptions. Doesn't have to be an agency adoption. Those contents are under 161-106. It's also 2 witnesses and a notary. It doesn't have to include an admission of paternity. In fact, I have had cases where I've specifically stated in the waiver that while he understands he's been named by the mother as an alleged father, that he does not believe he is not admitting paternity, things like that. I have definitely put that in there. And it cannot be used by anybody else to establish his paternity. Sometimes that is helpful for the alleged father to know. Most of the time, they don't care. Involuntary termination. So if you've got somebody who isn't signing their relinquishment or waiver, then that means you're going to have to involuntarily terminate their rights. There is a list of the grounds in Family Code 161-001. I'm sorry, I should have removed that Exhibit A reference because I did not do a paper for this like I normally do. There's a lot of things on there, like voluntarily left the child alone or in the possession of another, not the parent, expressed an intent not to return, failure to support within their ability for a certain period of time, things like that. So there's a long list of items. With an alleged father, under 161-002, with our paternity registry, if the child is under the age of 1, if they fail to register with paternity registry, you can terminate without notice to them. I would be cautious about not naming someone in your pleadings because there's some conflicting case law out of Houston about if you name them, you have to serve them. So what I typically do is, if on my newborn cases, if we have an alleged father who's not signing, I do not name him. I just allege that they haven't registered with the paternity, or if they don't register with the paternity registry, that they aren't entitled to notice and their rights can be terminated without notice. I also, in almost every case, unless I've got DNA telling me who the father is, I will include terminating potential unknown, unnamed, or unidentified fathers based on the paternity registry. So I definitely recommend doing that as a catch-all. It is more than once I have had situations crop up where the birth mother swore somebody was the father. He answered, we did DNA, and he wasn't the dad. You do have to prove your grounds by clear and convincing evidence, and you have to prove best interest, whether it's voluntary or involuntary. You have to prove best interest by clear and convincing evidence. Your petition, I always include any grounds. If I'm using failure to register and I'm not serving the alleged father, that's the only ground I use on the unknown, unnamed, unidentified father, because you can't get them on the other grounds without serving them. You need to allege best interest of the child. I typically attach relevant documents. So ICPC affidavit, if I have to do a UCCJEA affidavit, if there's a party out of state, if I've got relinquishments or waivers, all of those, I typically file all of those as exhibits to my petition to the extent I have them available when I'm filing. The caption should, of course, only use the child's initials, and you need to make sure you're including that sensitive data notice up at the top. Most of the time, I am filing after relinquishment has been signed. If you want to file pre-relinquishment, you can do that if it's an agency or CPS, the department. If it's a private individual, you're going to have to check your standing, because if, for example, on my newborn adoptions, normally they don't have standing because that baby hasn't even been born yet. So certainly hasn't been in their care. So you got to be careful about your standing if you are filing before relinquishment in those scenarios. Service. Typically, you're going to serve any parent who has not voluntarily relinquished. The only exception is, again, alleged dad of a child under 1, or if you've got a situation where the mother does not know who the father is, child could be 5 years old, and she's like, I have no idea. And after due diligence, you can't identify them. You can also use paternity registry in that type of a scenario. And then you don't have to serve them. If you are doing citation by publication, be sure you've got your due diligence affidavits on file. You usually have to do that to get your order. I'm sorry, excuse me, my voice is a little rough this morning. You also now, if you're doing cite by pub, you have to post on the public information internet website. And actually, the court clerks do that, but you do need to do that under TRCP 116. That's as of last July. And I was actually the first case that they did that on at the juvenile courthouse in Dallas last year. So that was fun, trying to figure out how to make all that work. An adoption evaluation. You do have to file it is no longer called a home study, hasn't been for years, but people still refer to it that way colloquially. Under the code, it's the adoption evaluation. Has to be filed in any termination suit that's not involving an agency. So if it's the department or a private agency, you don't have to, but if it's a direct placement with your family, it is supposed to be filed in the termination suit, and it is needed in every adoption, including step-parent adoptions. I have people, and you may be asking this question, well, I had a judge waive it. The statute is a shall statute. There's no provision for waiving it. You can compare it to the surrogacy statute, which does have provision for waiving a home study. Adoptions, there's no provision for waiving it. So I file one in every single case because otherwise I feel like you're potentially jeopardizing it. Does have to be a qualified evaluator, family court services, or if it is an agency and a licensed child placing agency does it, they're automatically qualified. You have both a pre-placement and a post-placement portion if you're talking about a situation where it's a newborn or the child isn't already in the home. You're going to do pre-placement and post-placement. If the child's already in the home, step-parent studies, a lot of relative cases. I think most DVAP cases are going to be situations where the child's already in the home and has been for a while. Those are combined into a single report. When it comes time to do your trial or your prove up, obviously uncontested, you can do prove up For those of you who are litigators, you're familiar with that concept. You want to make sure that you have any of your amicus or ad litem's involved, and we'll talk about that in a minute. If you're doing a default, make sure you got your service members affidavit. If you're doing it after publication or other alternative service, you need to have that statement of evidence as well. If it's contested, it can be a trial to the bench or to a jury, which is something apparently pretty unique to Texas. Most of my colleagues around the country are shocked that a termination case would go to a jury. But yes, it can be requested. A jury can be requested. It can. I will warn you, if it is a contested case, and I've got 2 of them that have popped up on me in the last month, the new discovery rules do apply to these cases. So that does mean that once an answer has been filed, that's going to trigger those initial required disclosures under 194. So be sure you are looking at those if you aren't already familiar with those. And of course, don't forget best interest of the child. You've always got to put on some evidence of that. Even in a prove-up, it can be a pretty simple statement about it. But in contested, obviously, you want to make sure you're putting on a lot of evidence about your best interest. Your termination order, the minor child will retain the right, a minor child being adopted will retain the right to inherit through biological parents unless the order provides otherwise. You do have to include a finding on the continuing jurisdiction, either that this is the court of continuing jurisdiction, or you search the Bureau of Vital Statistics and there's no continuing jurisdiction, or you said that you're not required to search because nobody's contesting the jurisdiction and venue issue. Appoint PMC if you're not doing an adoption combined with it. I usually specify the rights instead of just saying they have all the rights of a non-parent managing conservator. I usually do literally list them. You do not have to send the birth parents a copy. It does have a 30-day appeal period. And if it's based on the voluntary relinquishment or waiver of interest, it can't be attacked after 6 months. That would be an affirmative defense. And actually, within that 6 months, can only be challenged for fraud, coercion, or duress. When it comes for sealing the record, I will tell you Dallas County will automatically seal the record, whether you ask them to or not. It is automatic in Dallas County. I don't know that that's true in every county, but definitely in Dallas County. Most of the time I am sealing the record. The times I don't want to are usually like step parent adoptions or something, and the court still seals the record. It's just an automatic thing done in the clerk's office. Amicus Attorney. So unless it's a case with the department with CPS, it is discretionary for the court to appoint an amicus attorney. In CPS cases, that would be the guardian ad litem or guardian attorney ad litem in a dual role. But in private cases, it's an amicus attorney representing the child's best interest. They do have similar powers and duties to an attorney ad litem for a child, but they are not bound by express objectives of the child. So it's more like a guardian ad litem in that sense. I will tell you the juvenile courts in Dallas County, the 304th and the 305th, require them in all termination suits. Over at George Allen in those courts, it just depends on the judge and sometimes on the facts of the case as to whether the judge will require it in those courts. Again, guardian ad litem, attorney ad litem in the dual role for the child. Those are only in department case. A guardian ad litem is only in a department case. It's mandatory in those cases. If they're an attorney, they must serve in a dual role, focus on best interests. You can see what this says. Most of the cases that you would be doing with DVAP are not going to be department cases. They're going to be private cases. So this is going to be less likely to apply. Attorney ad litem for the parents. In department cases, it's a mandatory appointment if a parent comes in and says that they are indigent and fills out the paperwork as proof of that. In private cases, private agency, private direct placements, they are discretionary. In my experience, most of the time, the court is going to appoint one. And in those scenarios, the petitioner is paying those fees, not the state or the county. like they do in TDFPS cases. You do have to have an attorney ad litem appointed for anyone that's served by publication or alternative service, because they have to check on the due diligence of the petitioner. The court can appoint one for an alleged father you're terminating based on failure to register. I will say, unless it's mandatory in department cases, typically they do not. I've never had them do it in any of my private cases. If you are an attorney ad litem and you're representing alleged father, you need to make sure that paternity registry has been checked and that you see the certificate as well. And that appointment does continue through any appeals, absent a determination that the parent, if it's been appointed for indigent parent, absent determination no longer I'm having a problem with that word. I'm sorry, indigent. So now we're going to move on to step 2. Step 2 being the adoption. Again, as we've said before, it can be combined with a termination suit. That might not be prudent, particularly in newborn cases, because if you're wanting to get your termination done quickly, and that's a relative term these days, most of my terminations are taking 3 to 4 months, because I get a paternity registry on all cases. And those take time to get. So on my newborns, I do not combine them, but I do combine them. I've got a couple of relative adoption cases going on, step parent adoption cases, those kinds of things. I almost always combine them in those scenarios. Again, the UCC-JEA does not apply to an adoption. If you're doing adoption and termination, it's going to apply because it applies to termination. If you're just doing final adoption, you can go ahead and file in the previous court where termination was done. Or you can file in the county where the child or petitioners reside pursuant to the Family Code 103-001B. There is some arguments to be made about if you're including a termination, can you also file in those counties? I believe you can if termination was, or if the court of continuing jurisdiction is in Texas. So your subject matter jurisdiction is in Texas. I believe you can file, let's say, termination was done in, or a divorce was done in Collin County. And so that's a court of continuing jurisdiction, but now the child and the petitioners as step parent adoption live in Dallas County, have been in Dallas County for years. I believe you could file the termination and adoption in Dallas County under 103-001B. Some prerequisites for adoption: if the petitioner is married, the spouse has to join in. If the petitioner is not the managing conservator, so if you've got a family that's adopting from the department or from an adoption agency, or I recently have one where the grandmother of the child is managing conservator, parents' rights were terminated, she's now placing the child with another family for adoption. Have to have written consent of the managing conservator. If the child is 12 or older, they also have to consent to the adoption, either in writing or in open court, or both, but one or the other. The petitioner or petitioners and the child should appear in court. If they're over age 12, it is required, unless you get it waived. It can be waived if it's unduly difficult, or for the child if it's in the child's best interest. So for school, things like that, I have had it waived. Most of my prove-ups now are by video, which has made it very easy for people to appear. So it's a little bit easier. In the past, I've had situations with people out of state that didn't want to fly back with an infant, and therefore just one of the adoptive parents flew back and did the hearing. Required documents in your adoption. So you got to have your ICPC affidavit, UCC-JEA affidavit if that applies, termination order, or if parent's deceased, a copy of the death certificate, something to prove that they're just your adoption evaluation, pre and post parts as applies. You have to have a health, social, education, genetic history report, except on close relatives. That's going to be the grandparent, aunt, uncle, adult siblings, step parents. Those don't need them. criminal clearances on the adoptive parents dated within 12 months. So this includes as a step parent. I will say something that has come up sometimes in adoptions, step parent adoptions, is they do criminal clearances as part of the home study on the actual biological parent, because home studies, anybody age 14 and over in the home has to have a home study and child abuse registry check run. But you only have to file with the court for the adoptive parent. And then if you need consent of managing conservator or the child, as we've discussed. Your order needs to include several things. Have to have a finding that all of the requirements have been met. Be very specific. State, you have filed the ICPC affidavit, you have filed the UCCJEA affidavit, managing conservator's consent or why that's not required. You should also include findings in both termination and adoption orders that the Indian Child Welfare Act does not apply. Findings that you filed your home study, all of those things, be very specific. You need to state that the adoption is in the best interest of the child. So if you're doing a joint termination and adoption case, make sure in your order you have two different best interest findings. You have to have a best interest finding for the termination and a best interest finding for the adoption. Don't combine them together, two separate statements. The court finds it's in the child's best interest to terminate parental rights of XYZ. Court finds that adoption of the child by petitioners is in the best interest of the child. Two separate statements. Sorry, I don't know why that rolled back like that. You can also include a name change in scenarios where you aren't going to change the name. That doesn't happen to me very often, but every so often it does. I include a statement that the court is confirming that the child's name is whatever the child's name is, just so it's clear you didn't forget to include name change. And again, sealing the record, it's always an option. Dallas County is going to do it in all adoptions. Amending the birth certificate. So this has gotten a little trickier over the years. You have to do a certificate of adoption, which is Vital Statistics Form 160. If they're born in Texas, you're going to need to mail in. You also need a mail-in application form. That's the Vital Statistics Form 140. I do the expedited. Expedited takes about 4 months, and I said months. If you don't expedite, it takes, I think the last I was hearing, it was closer to 8 months if they aren't expedited. That does have to be notarized. You have to have a copy of the photo ID of the parent who signs it, all of that. That's all pretty well explained in the instructions. If child is not born in Texas, I always check with that state's vital statistics to see what they want, if they have their own forms and things. I still do a Texas certificate of adoption. If that state has a certificate of adoption, I do that. I always include a certified copy of the adoption decree, check for the fees, whatever else that state may require. So it says good luck and thank you, but I do want to cover a couple of things. I want to go back and talk a little bit more about Indian Child Welfare Act because we do have some time, and then I will get to questions because I see that a couple have popped up. Indian Child Welfare Act is a bit in flux, as you may know. There are some appeal cases going on out of Texas saying that it's unconstitutional. It is on its way up to the Supreme Court. Right now, I still follow Indian Child Welfare Act if I believe it applies. But you've got to do an assessment as to whether or not it applies. And the key is the child an Indian child? So if the child is a member of a tribe, federally recognized tribe, then yes, they're absolutely an Indian child. If the child's parent is a member and the child is eligible to become a member, as determined by the tribe, they're an Indian child. So if you've got a parent who says they have Native American ancestry, you need to explore that very carefully. Are they registered? Do they know who what tribe? Are they registered? Do they know the last family member that was registered? In a voluntary termination, you can do ICWA consents, ICWA compliant consents, they have to be done after 10 days. There's a whole lot of requirements. They're revocable until rights are terminated, so on and so forth. So it's got a lot of requirements to it. If it's involuntary, you have to give notice to the tribe. Some states do have what's called a mini ICWA. They have their state level ICWA that has certain different requirements. I know Oklahoma does. I think Washington State, lots of states. Texas does not. So we just have to deal with federal. So that is one thing to be aware of. Paternity registry, I know I've referenced that a lot. So I want to tell you a little bit more about how that is working these days. Paternity registry, basically a man has 31 days after birth to file with the paternity registry to be entitled to notice. That means that you need a paternity registry. If you're going to be relying on paternity registry certificate, your certificate has to be dated more than 31 days. You used to be able to fax those requests in. You can't do that anymore. You now have to mail them in. It does say that you can expedite. I will say the one time I tried expediting one, it took longer than any of my other ones did. So I just send them by normal. They're taking anywhere at least 4 weeks, usually closer to 6, sometimes a little bit longer. I typically, before I was not setting my prove ups until I had those. Well, right now the courts are setting so far out that if I set it for 8 weeks after I've sent the paternity registry, I just don't set my hearing until at least 8 weeks after I've sent it, because I should have it back by then. So just be aware of that. If you've got a child over the age of 1, I still would check the paternity registry unless you know who dad is. You've got DNA or whatever. I would still check paternity registry and get rid of potential unknowns, even if you've got alleged dad signing, you've got presumed dad, whatever. I still check on every case unless I have a DNA test, just because I have seen that come back problematic. So I'm going to stop sharing my screen now. And I noticed that we've got some questions and stuff in the chat. So I'm going to start with the Q&A. Let's see. Laura asked, if you want to do termination adoption at the same time, do you file both petitions first, or do you include the petitions and orders? So it's not two separate. When I do them together, I do a single petition. I just do it. I do, it's a petition for termination of parental rights and for adoption. And then all the, base stuff at the beginning, identifying the parties, all the termination stuff, all the answer stuff. So it's all in a single petition. I all do a single order. So I don't do separate ones. I'm not sure if that answers your question. But I file a single petition up front. There usually isn't an order to file. So hopefully that will answer that question. Let's see. After the affidavit of relinquishment has been signed, how soon do I file the petition of termination with the court? That kind of depends on the case. On my agency cases where it's irrevocable from the time it's signed, I usually file pretty quickly. On the cases where it's a private one and it has a 10-day revocation period, sometimes I will wait till that revocation period runs out, or we're pretty close to it. Depends a little bit on the facts of the case. But usually I don't sit on it very long most of the time. Most of the time I'm going to file it pretty quickly. Let me see here. Jed asked, are the requirements to examine the health or physical conditions of the petitioner or the child? That's the home study requirement. That's the adoption evaluation. The adoption evaluation is done by usually a licensed master social worker. There's some other qualifications, but that is going to include usually the prospective adoptive parents have to have physicals, home visits, all of those things. As for the child, it depends a little bit on, if you're talking about a newborn, usually you're going to be getting medical records on some of that. But if you're talking about an older child, it kind of depends. If the child does have some obvious issues, there might be some more exploration into that on the home study and the evaluation, adoption evaluation. So hopefully that answers that question for you. Are prove-ups in person? Do the adopted parents have to be there? Cases in 256. You're gonna have to ask your court. The 304th and the 305th, which is where I do most of mine, are still doing them by video on Microsoft Teams. Most of the courts at George Allen, I think, are still doing them by Zoom last I checked, but I do almost nothing at George Allen and pretty much haven't during COVID. So you will have to check with the court coordinator on that. You could probably, if you wanted it to be by video, you could probably request that at this point. They're still pretty good about that, but they may still be doing them by Zoom. I know the courts over at George Allen are using Zoom, so they may still be doing that by Zoom. You'll have to check with your court coordinator. Order of termination mentions in section 11 medical history. Court finds that medical history of the subject child. What does that mean? Is this the form that the parent? So I don't know what order you're referring to. My orders of termination don't reference a medical history. They only reference the health, social, education, educational, genetic history report, the HESIG. If this is like from the department or something, that could be the medical history form. That's actually not required to be in the order. You have to have a HESIG, but the HESIG and the medical history form are actually two different things. So I'm not sure. I'm very sorry. My computer just did something very weird to me. Okay. So hopefully, I'm sorry, I'm not sure that answered your question. But it wouldn't be something you get from the doctor. I would assume that they're talking about the HESIG and then the medical history form. That's actually a form that's set up by Vital Statistics, I think, that anybody who signs a relinquishment is supposed to fill out. So the birth parent should be filling that out. Do they do it all the time? No. Oh, good, Laura, I'm glad. Seen petitions filed with the full name of the minor children. So the petitions have to have the child's name in the document down within the body of the petition. The caption should not be the minor child's name. The rules of civil procedure are very clear. Child's name is not supposed to be in a caption. It's only supposed to be the initials. You do, however, in the petition, when you're identifying the child, need to use the full name of the child in the terminations and adoptions. Where do I have background checks done for parents? So usually the adoption evaluation person will take care of that. But yes, if they don't, I do send them to Identigo. That is true. That is where I send them. How do we schedule the home study? So I always use private home study providers. I do not use family court services. If you're going to use family court services, you need to check with them on their procedures. Kathy may be able to tell you, or DVAP may be able to tell you, but they just take a long time. So I don't use them. I have private processor or private home study providers who are with agencies or whatever that I use and recommend and send my clients to. And I just have my clients schedule that with the provider directly. If you're using family court services, you have to get the court to sign off on the family court services order, and then you submit that to family court services. And my recollection is family court services then contacts your clients to schedule that. If you're doing a two-part process, uncontested step-parent adoption, can you file the adoption prior to completion of termination? Well, if you're doing a step-parent adoption, I wouldn't file them separately. I would file them together. If you've already done the termination, filed the termination, I would either amend it to add the adoption to it or wait till your termination is completed to file the adoption. And then typically I do keep them in the same court unless there's some reason not to. Not sure that answers your question. Probably need to know a little more before I can answer that for sure. How much is private family home study? Home study prices vary pretty widely. I will say, I think most of the people I use charge between $1,200 to $1,500. Step parent study might be a little bit less. That doesn't usually include post-placement. So it just varies. I know if you're using family court services, they've got a scale that they use, and I can't tell you what that is. But typically, I think most of my clients are probably paying $1,200 to $1,500 for the pre-placement study. And then I think in private adoption, direct placement, they only have to have one post-placement visit around the 4th or 5th month. And I want to say most places are charging about $800 to $1,000 for that. But it just depends on the provider. Every provider is going to be a little bit different, and you just have to find out from the provider. So that's the ones in the Q&A. Let me move over to the chat. Do I still have time? Oh yeah, we got time. Okay. So evidence of what would constitute best interest of the child. So if it's an uncontested case where I'm just doing a prove-up, my question is usually, based on your knowledge of the facts in this case, do you believe it's in the best interest of the child? I usually just do a very simple, yes, I do. If it's going to be contested, then best interest of the child is going to be those factors in Holly v. Adams. If I remember I'm hoping I remember that case right. And there's a long list of things, and you're going to end up, things about bonding. And I mean, there's a long list. And so you would just follow those factors and give any evidence you've got on those factors. Typical cost for an amicus attorney. Again, that's going to vary a little bit. Going to vary by what courthouse you're in. I will say the amicus attorneys over at the juvenile courthouse tend to be less expensive than the ones I get appointed over at George Allen. Typically the ones I see them range anywhere from uncontested agency adoption, where it might be as low as $300, $350. I've seen them go up to $1,000 or so in uncontested. If it becomes contested, that's a whole nother level, just like any other attorney's fees. See here. I think I've already asked the question about if you're doing uncontested step-parent adoption as 2-part. Again, I wouldn't do it as 2 parts, but if you've done it and you've already filed your termination, again, I would either amend your petition to add the adoption, or you wait and file the adoption after the termination. You're not going to file a new petition while your termination is still pending. You just would amend your petition. I think I already talked about the one with the names of the child in the petitions. Custody evaluations have to be done for grandparents or great-grandparents, even when they were previously appointed at managing conservators. So custody evaluations and adoption evaluations are actually technically different. Under the code, they're very different. Yes, even if they are, the relative is already managing conservator or whatever from a previous custody proceeding, grandparent or step parent, any of that, they still have to have an adoption evaluation done. I will tell you, my home study providers typically charge a little bit less when it's a relative situation like that, step parents or grandparents who've had managing conservatorship, that kind of thing. But yes, you still have to have an adoption evaluation done, because it is different than a custody evaluation, and that does have to be done in the adoption. Will DVAP cover the amicus attorneys? So I don't want to answer for DVAP, except I'm pretty sure the answer for that is no. And the reason I'm pretty sure the answer for that is no is because I am occasionally appointed as pro bono amicus attorney on cases, because I will take cases occasionally for that. DVAP will typically help you find an attorney who will take it pro bono. Kathy, please chime in if I'm wrong about that. But I think that's right.
Yes, DVEP will help.
But you don't actually pay the fee. You just help find an
No,
attorney that does it pro bono.
Right. We get somebody to do it pro bono. Right.
Yeah. Okay, let me see here. If we're doing termination and adoption, does the home study at the same time? Does the home study have to be done at the same time as the home study? Or do we do the petition first? Okay, I'm sorry. That question, I don't understand that question. So if we're doing the termination and adoption, does the home study have to be done at the same time as the home study? Or do we just do the petition first? I'm afraid I don't understand the question. I will say, if you are doing a situation where child has not been placed in the home, you're going to do a pre-placement evaluation before the child is placed. That's usually going to be before you're filing your petition. If you've got a situation where child is already in the home and therefore the adoption evaluation is going to be combined pre and post, you can do it before you file the petition or after you file the petition, unless of course you're trying to use family court services and you need the court to order it, then you've got to file the petition. I will say in majority of my cases, not all, but most of my cases, I have the home study, at least the pre-placement home study, before I file my petition. Not always, but usually. But I've got like a couple of family ones I'm working on now that we filed the petition once we had relinquishments or whatever, and are waiting on the home study to be completed at this point. So I don't know if that answers your question. I'm sorry, but hopefully that did. Do you need to include post-placement language in the petition for a non-relative adoption? That's probably fact specific, assuming that you're talking about a scenario where child is not already in the home, because that could happen even with non-relatives. And so you are having separate post-placement, then in my petition, I do reference the adoption evaluation and the post-placement separately. And if you're needing the court to order that for some reason, then you do have to obviously include a request for the court to order that if you need it. Can I name any independent agencies I use for custody evaluations? If Thelma, if you want to email me, I can give you the names of the people that I use. I've got a couple of people that I recommend. Susan Etheridge and Melissa Robinson are the two I use the most, but I can, if you'll email me, I can get you their contact information. Let me see. And then Julia, you've got, if your termination is due to an extramarital affair and the father wants to relinquish, should he be required to pay child support if there's no adoption? If his rights are terminated, he's not going to be required to pay child support because he's no longer a parent. He no longer has that obligation. I will say, I think you're going to find it hard to terminate in that scenario, at least in Dallas County, based on just because the father had an affair and doesn't want to pay child support. But if you terminate his rights, he's no longer a parent. That means he no longer has an obligation to pay child support. So he doesn't have to pay any child support after termination. You're not going to get support after that. Pre and post placement person does not need to be approved by the court in a private placement. So Laura, that is a good question. I will tell you, my judges have always accepted my adoption evaluations because in part, I think they know that I'm using people who are qualified. So it sort of depends. If you're going to do family court services, you absolutely have to have a court order to get that. Some judges may be a little more reluctant to accept a study from somebody they don't know. I know of at least one judge in Dallas County, was not my case, but did order a second study done by somebody different because they didn't approve the first one. So a little bit of it is a little fact specific, but typically I don't get it ordered because you've got to have the pre-placement study done before you've got anything filed in court. And so like with most of my agency adoptions, no, because the agency is doing the home study. So let's see here. What are Dallas judges most likely to do with child support arrearages? I don't have that come up in my cases very often. I will say that termination does not eliminate child support arrearages. Those are accrued, and I don't think you're going to find a judge who's likely to wipe those out. I could be wrong, but I think odds are you probably are going to find a judge anywhere willing to wipe out the child support arrearages, because those are mostly accrued to the child. And then, is it best practice for the child not to inherit from the bio parents? I think that kind of depends. I will say in my private adoption cases, I do typically include that they do not inherit. I do cut off the inheritance. In the agency adoption cases, I don't usually include that. In part because usually in the private ones, there's a little more transparency than in the agency scenarios. Although granted, I would say most of the time the bio parents in agency scenarios probably aren't going to have much for a child to inherit anyway, sadly. I don't know that I would say that there's a specific best practice on that. And I think I got all the questions.
Thank you so much.
People can always email me. I'm sorry, Maricela. People can always email me. It's jenny@wamickadoptions.com. It is on the PowerPoint, which I think is either has been or will be sent out.
Correct. It will be sent out following today's presentation. And again, thank you, Jenny, for presenting this afternoon. And thank you to everyone who joined us via Zoom. We ask that you please self-report your MCLE credit through your State Bar of Texas profile. And you can use the following course number, which is 174-138-532. Again, that's 174-138-532. And it's also included in the chat, but will also be emailed following today's presentation. Thank you, everyone, again, and we do hope that you have a good rest of your afternoon.
Thank you, Jenny. Thanks, everyone.
Thank you. Bye, everybody.